to kind of get into our lesson for today, and hopefully we'll have some good interaction on this. But last week we talked about the power of a word, which we frequently talk about this general subject, but we talked most specifically about accept and acceptance. And we looked it up in Black's Law, 4th or 5th edition, to get an idea what these words mean. When I tell you, and I get this all the time, because it shows, I can tell immediately when somebody's not doing their homework because of their response. I'll say, you need to accept it. And they go, oh, I don't want to do that. They're the violators of the law, and they're doing this and they're that, and I'm a sovereign and glowing on the land, and I walk on the clouds, and I'm a Moor and a patriot, and blah 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 blah. But all that's just making claims about who you think you are, and it doesn't matter. What matters is how you close the transaction. And very few people want to work at studying to learn how to do that. And yet it is the key to winning so many cases. And I'm going to prove it to you today. I'm going to show you how I took somebody who knew very little, and with a couple of phone calls and a couple of documents, they were able to have success on a very serious case. So stand by. I'm going to show you that. But I didn't know that testimony was going to come when I taught this last week. But sure enough, there was an opportunity to assist somebody with that approach. Now, you've heard us talk about doing equity and equity training. Equity is not like a one strategy approach to everything, but it is a philosophy on how you approach things. So you have to still think your way through it. There's no template. There's no script. I mean, there are sort of scripts, but the scripts are not going to work when they start challenging you. You're going to have to know it like it's in your brain, and you just totally can just come up with the right response on a moment's notice. So when I teach the concept of acceptance, which is essentially a part of an equity process, it really, really can have a powerful effect on things. So I'm going to show you, again, an example. And it's not a conditional acceptance. That might help you get to an acceptance, but you don't have a deal till you get to an acceptance. So you're always shooting for the acceptance. Conditional acceptance might slow the thing down and get you closer, but we need to see a real-world example about how that works. So, and I don't know if we have this member on tonight, and if we do, he can come on and make comments. But what I did is I wrote a summary of what happened here. So I'm going to read through the summary, kind of give you an idea of what really went on. And it'll show you how he was trying many things. Some of the things he got from our site, some of the things he got elsewhere. Problem is that he was throwing everything against the wall. And that rarely works. But people do it all the time. They throw everything at the wall instead of taking the simplest possible thing. And I'm going to show you how he took all that, made it very simple. I had to hear about what he was saying and doing, and I could see how he was sort of all over the place and what the court was trying to do. And he demonstrates everything we teach, how the court will test you, how they will challenge you, how if you use the wrong patriot theories, how that's going to make it more difficult. I'm not going to say it won't work. It just makes it more difficult. And why make things more difficult? The reality is when you go to a court situation, you want justice, right? I mean, if you're truly innocent, you certainly want that to come out. If you didn't do any real harm, but you knew you were breaking the rules, well, you might pay a little bit, but you want to get out of that as cheaply or with less time as possible, right? I mean, to be realistic, to think that I just want to get away with everything without having any responsibility isn't going to happen. It never has happened in history. It's not going to happen in the future. We do live in a society, and once you accept some of those society's benefits, you have to live by those rules. You want to work for McDonald's, you got to live by the rules of McDonald's. You want to be a U.S. citizen and take the benefits of a U.S. citizen, you got to sometimes deal with it under that status. And you don't go around saying, I'm not this or I am that. You simply ask questions that take control of the situation. So we're trying to teach you more about how to ask questions than it is to make claims. And making a claim is to say, well, I'm this and I'm that and you're this and you're everything. All those things are claims. Or I'm the name and I'm an all capital letter name and you can't touch me. Well, there's a right way and a wrong way to handle that. So we're trying to get better at teaching that to you. That's why we're doing an advanced equity course right now that's been ongoing for about a month. We're into session 3. It's still not too late to join that at this date. Now, in the near future, it probably will be, but we do have a couple of people still signing up. And you can catch up for sure. But we have a lot of exercises and homework that's required to do that process. It's meant to really change your way of thinking. But if I can do it here at a smaller level, at the sort of the premium member level, hopefully you'll pick up something that can help, and know that we can still offer you some coaching to get through situations. Just contact me about that if you have a situation. And, talking about what the appropriate honorarium fees might be for that. So, in this story, and I'm going to leave the names out and just kind of make it a little bit anonymous, but I can assure you I could show you the guy's name if he gave me permission, but I don't like to give people's information out, especially on a very, very current case. But this person started out ordering our status package, and I'm just going to summarize what you see on screen. I'm going to put this up entirely in writing on a blog page here shortly, but for now I'm just going to summarize it. And he started out by saying, "You're a blessing, man. I deeply appreciate you and your work. The charge is driving under restraint, that is, without a license. Basically, his license was revoked to a previous DUI, driving under the influence, right? And he had no proof of insurance, and he did a lane usage violation." So a few things there. Once you get to that DUI category, it gets serious. You're talking about misdemeanors and possibly even jail time. So anyway, he said, "The fact is I do have insurance, simply didn't have it with me. I was not aware of the license restraint issue." So he didn't go on the road and start challenging the cop. He just dealt with what came at him. So I knew there was a miscommunication between the DMV and the breathalyzer machine. He had a machine in there. And so anyway, they suspended his license without him realizing it. And then he had a trial date set on this when things started to happen. Again, he wasn't aware of some things. So, and as I say, and as I reminded him, it's harder to buy the insurance after the fire starts, but let's see what we can do in this particular case. At least he hadn't gone to trial yet. I told him just, well, it's about proof of insurance. Okay, we can play the game. Oh, you can't prove I need insurance, blah, 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 blah. And that can get worse and worse, especially when they kind of caught you at something. So it's better, in this case, I said, if you got the insurance, why don't you just get proof of it and send it in? Or at least send it in with some documents that I suggest we put together. So he gave him some evidence, and he's simply taking responsibility. And that's what we should all always do. I mean, if you take responsibility, you're going to get a lot further than denying the obvious. So notice is always important. So I said, be careful of using any sovereign patriot tactics at this point. He's already done enough of that. He's ticking people off, and it's not really getting him where he wants to be. He had a winnable case on the facts. So I said, here's what we need to do. We need to do a conditional or full acceptance approach and avoid the trial and avoid the controversy altogether. Settle the matter. And in his case, he was thinking, well, maybe I'll settle it and get my hand slapped for not having a license, and maybe I'll drop everything else. He was, at least he was shooting for something less, which would have been pretty harsh if they'd gotten him on it. So we weren't sure how it would turn out. We never do. But my point is, it's going to cost you a lot of money and time to play that game. And so, since he can prove insurance, he can start off in good faith by bringing that out right up front. And he clearly wasn't trying to get away with something. We don't teach you to get away with something. You're not paying something that you probably really do owe. Or, and if it is, maybe it was something that was loaned to you, but in fact that was based on fictitious credit. That's a little different. But I mean, if you harm somebody and you owe them money, you should pay it. But we want to mostly focus on the undamaged party situations. This was merely administrative stuff that they were arguing. So, again, he's Phil, as we said before, he's already pulled over for this and had expired permit. He really didn't know what to say. And so 2 years ago, all this stuff had happened with the DUI, and he had what's called an SR-22 insurance, which is kind of a specialized insurance that you can use while you have a DUI, and a breathalyzer machine installed in his car. And anyway, he'd already completed everything, done everything he's supposed to do. He acted in honor and took care of his obligations. Then he found UR Law. And before he started seeking private coaching, though, he went on and tried some things. He contacted the DA directly, as we talk about doing. And in his case, he expressed the trust. It's a document and an approach that you can use. gave him 21 days to respond in writing for proof of claim and evidence of lawful authority. And again, he kind of mixed some things there now. And he's making when you express the trust, you're not making an argument, but he kind of did that. So that's where one thing started going wrong, is mixing processes. And basically it was just a verbal request at this point. Then you put a letter regarding the right to subrogation to the clerk and the prosecuting attorney. And after that, you put in a 4-page document, notice of appearance, mandatory judicial notice, motion to dismiss, notice of subrogation at the hearing. Now, I don't know how much he was mixing and matching there, but he started throwing a lot at them. The question is how much did he really know in his head and in his heart so he could stand on it? That was where it started getting challenging. I thought, based on what I saw that he had been doing, I think he's throwing too much at the wall. Sometimes you have to stick with one thing and stick with it. But anyway, the judge denied it, which they typically are going to do, which is what we teach might happen. And then simply say, I do not consent to proceed without an answer, and then I don't know what tone he used and so forth, but he was all over the place, it sounded like a little bit, but he was kind of on the right track. So anyway, the judge entered the plea, because essentially he is acting like he did not appear. That's very important. We teach you now to make sure you appear in both capacities so they don't pull that game on you. And anyway, that's how it all went on a WebEx type meeting. And then in the next appearance, he did the same thing again, which is again part of what was taught. Stay on point, stick to it. They're just trying to retest you all the time. And then this time he started asking for the securities, and of course they ignored it and acted like they don't know what he's talking about. We tell you to expect that. They can't acknowledge some of the private things in the public. You got to get that. They know not to mix the public and the private. So when you bring it up, you're kind of stirring up the pot. And anyway, they played the tactic of arresting him for contempt. So be prepared. Sometimes when you do those things, that might happen short term. But if you stay on point and don't become double-minded, it'll continue to work. So anyway, he says, I learned what you mean by being tested. That's right, it does happen. So anyway, they brought him into the hearing, and then they said, well, basically, if you don't, they started bringing up the issue of, they wanted to hit him for contempt of court, for violating the video and audio recording procedures. So they're on to something new now, right? So they want to get on anything but the issue he's bringing up. So they pointed out that they could put a warrant out and arrest him and so forth for doing that. So that's what he did. He had done some recording. He maybe wasn't aware of the rules. He says he didn't receive notice of it. That's fine. So anyway, when he signed everything they gave him, he did it with reserving his rights, which is always a good way to do it. You go look up the term, all rights reserved and without prejudice. Then you'll understand why those words are so important. When you sign something, it limits your liability. So then he decided, I better get a coaching package to get this thing straightened out. So he contacted us, and most of our conversations were via our Telegram and a phone call, basically. The first thing I told him was, stop making statements and claims. Stop saying this, and you're this, and I'm that, and you're this, and those are all statements. Start asking, and let's get this thing closed. You got to go for the deal. Close the deal. So it's all a negotiation. Always remember that. So I talked about the definition of acceptance, like we spoke about. And that video, by the way, is on YouTube. It's also in our premium member area from last week. And I said, think about conditional acceptance, or even better yet, to get to a full acceptance. And I realized where he's at just before trial here, and because maybe he didn't see that because he's caught up in it, but just before trial here, he has a very simple place to go. He could try to arguing the facts and getting into that, but that just seems to make it worse and worse and worse. And you end up hiring an attorney, spending tens of thousands of dollars to just end up back where you started from, which is what it means you're going to have to try to cut a deal. And I said, you can prove with some evidence, with your insurance and your other evidence you've got, just attach that incidentally with what you submit, but don't make a big argument about it. Let them see it. They'll realize that there's some weakness in their case. So you're creating leverage. But instead of going on about, you don't need to restate the expressing the trust and all that. In fact, that's already been said. But how do you close that deal when you say it? Just because you say it doesn't mean they're going to do something with it. So we need to go in and we need to close the case. Well, doing the acceptance is actually accepting the offer with your terms essentially that they've all agreed to. You're all agreeing. Let's just make this go. Let's settle this today, instead of fighting attitude. So after he came in with that approach, he decided, let me write this little letter. And so he drafted his own very short letter. I said, don't try to get into all the facts. Just attach copies of a few things you got, like the insurance and so forth, and just send this along in with it. And so in his case, he had a unique situation. So I said, let's make it extremely simple, because your evidence is going to speak. You're not making an argument. You're just simply accepting that maybe we can come to an agreement here and let's get this over with. So without going into an attorney and paying an attorney, he did buy some of our coaching. He had this status package, and we included this with that. But sometimes we just do it as a separate equity coaching. He received a letter. I'm willing to accept the charges. I asked for forgiveness. I didn't understand the rules fully. How can we get this resolved without delay today? So he sends that in before the hearing, giving them notice what his intent is. He does an appearance we taught him about special appearance, and there was some coaching we had to do on that. That's very careful that you have to do that. I told him, don't think of it as a standard script. Think about what you're trying to do and what these words mean that you're saying. If you don't know what you're just repeating something, you're going to get in trouble when they challenge you. And they did try to challenge him. They tested him several times. So we got him off that idea about templates. This letter, by no means, is a template. It's something he wrote after we had a discussion about it. And I said, looks like that might work. It wasn't one of our templates. It was his. And then I said, let's talk about special appearance. What does that mean? It means you're there for a specific purpose under a specific title. That is the full given name, which of course is not the name on their documents, but at least you're not avoiding the name and having them come up and say, let's send out a warrant for failure to appear, because that's what they do now. This is kind of the tactic they've come up with. Well, we address that now. We say, I'm here by special appearance. My full given name is full first letter, capital T, H-E-R-O-N, J-A-Y, M-A-R-R-S, full letter, first letter capitalized. And again, that's not how they're going to have it on their documents, but at least you're identifying yourself and telling them what you're there to do. By special appearance to get this settled today. That's all. No special. There was a few other words we used, but the basic idea is simple. Okay? We don't hide from the name. That's the thing that right now the courts have figured out how to deal with it when patriots come in there and say, I don't have a name, or I'm not that name. You're making statements. He was saying, I'm here by that name. He's just telling the truth by special appearance. For the purpose of getting this settled, how can we get this settled today? He starts off with the question. And it tells him that's all you're there to do. That limit, as far as the stuff what we teach about trusts and all that, that's all the bits that's just been incorporated in that. By asking that question, you're going to them and saying, here, you need to fulfill your duty and get this thing taken care of. And it does, without getting into the details of how that works through a trust and all that. It's just simply doing it by action rather than a lot of words. So anyway, then, after he did that, he had that appearance and he had that, and when he had the letter went, then he went and had his appearance. Then I get this email out of the blue. A few days later, thank you, TJ. I hope you're having a great morning. I wanted to let you know that they dismissed all charges. My family and I thank you. And here's what happened. I sent a letter of acceptance to the judge and, of course, to the prosecutor. And then I didn't have to say much. Came in as this special appearance, gave the name, and the clerk asked for my name, and he addressed himself again. I'm here by special appearance for whatever his name is, full, middle, last, no initials, no, you don't have to use all caps. Just do it as it's natural. It was originally given to you. That's all you have to do. The judge intervened, and he said he knows who I am. Now, that was interesting. The judge was now being honorable, and then the judge asked the prosecutor about the paperwork that was received. The judge then handed me an offer. I rented them down. Then again, I'm here by special appearance, and this is my name. He's always giving his full proper name, not the one that's on their documents, because it's never correct. And I'm here to, basically your attitude is I'm here to settle versus argue. That's kind of how you dialogue with them. The judge then asked if I had something to say about the recording situation, which is the recording of the audio video. He didn't respond. That was a test. I simply backed up what I had sent in, and I said, staying on point, I asked for forgiveness, and I said I didn't understand the rules clearly. How do we get this settled today? Something to that effect. And then shockingly, the judge simply dismissed the case. She then asked me if I was eligible for a license otherwise, and I said yes. She then proceeded to dismiss all other charges and void the fines. I simply went out and got the license taken care of, which means he's happily, he doesn't have a problem having a license. I don't have a problem having a license. It's not a problem to me because I know how to deal with it. It's for those who think that by getting rid of it, suddenly you get rid of all your problems. And sometimes it's just the opposite. It's a tool that the straw man uses. It's not me. But it does help me actually deal with my commercial matters. And that's what he just did here. He dealt with his commercial matters. And the court respects that. So he actually thought about putting more stuff in, adding more things. And I said, dude, you just got what you wanted. Get the hell out of there. Go get the license. Send it to the court as they asked, and be done with it. You got a lot of stuff released off you here. So, and now he wanted to know if he should go ahead and do the status documents, which is what he originally started with. I said, you can still do that, but I wouldn't mix it in now that you've got a remedy. Let's close the books on that. Go ahead and finish your status docs. That will affect you going forward. All that does is reinforce who you are publicly into the status document package we have. It's a special package you upgrade for if you want it. But you know, and then that just further proves who he is. But he really proved who he is by how he spoke and how he addressed the commercial issue. Technically, he could have done everything without anything special if he really understood how to do these equitable procedures correctly. And again, this was a very simple one. They don't always go this way. Sometimes they take more. There's more notices required and so forth in our advanced coaching that we do. But in this case, it was just enough that the judge saw he was being equitable. He was dropping all the other nonsense he was doing, stuck to one simple way of dealing with the contract and getting it resolved. So just a reminder, this is not legal advice. You know, there's more documents and disclosure about what we've discussed involved, but I wanted to give you the big picture idea about how it can work. And there is no template. You know, you have to have the concept down, know the definitions of some of these words, and that's the key to winning something like this. Okay, so I usually start off our Q&A with a success story. The reality is the success story this time is that story I just gave you. So, Omar, are you there?
Yes, TA, I'm here. Thank you.
How are you?
For having me. Very good, man. Thanks to you guys. I appreciate you guys. I love you.
You're welcome. Try to speak as close to the mic as you can.
Sure. Yeah. My only question is now that I am done with this thing, and I.
By the way, we didn't give this away, but Omar, by the way, everybody, is the person we just spoke about. So go ahead.
Yeah. So I'm just wondering on the status package, is that still something that I need to do, or do you think?
Oh yeah, I think it's still a good idea because it's going to help you strengthen your understanding of what you just did. You just don't, maybe you didn't realize you did something without fully understanding it, but it's going to get you a deeper understanding. Plus, you'll have record documents you can put in the record, and then you back up those documents with your behavior, with more knowledge going forward, and it can be used much more aggressively in the future. You just kind of can't bring it in though halfway through. Here we had just look what you had and try to get it resolved quickly as possible. But
right.
When you use that status information that's in there, it can be one more tool in your toolbox. Plus, it raises your knowledge. If you read that status document and really understand it well, you'll walk and talk what your status is, and that's far
right.
more important than just the document. But the document kind of sets it up.
Right. Yes. There is just one thing that I would like to recommend everybody. Like they know what they're doing, and the thing that I did all this Patriot and trying to cross the bar and all that, I thought that I learned that from you a lot. Then I started looking at where I learned this stuff, So, and I realized that I learned it from some other videos and stuff that I saw during the time trying to close all the gaps. So I think it's important to say that if you are hearing your law, you really need to write it down and be conscious of what you're doing and really pay attention of what you don't have to do, because that's what took me to jail for one day in
Yeah.
this case. And so yeah, that's all I want to say. And
Okay.
I'm still thinking on join the equity education. I'm just working on it right now. I hope I can still get a little bit forward
Okay.
in time.
Well, let me know,
Yeah.
as soon as you can, because we kind of we're starting to move forward with it, but some of that can be caught up with video and doing the exercises. We won't.
Right. Yes.
There's no guarantee we're not re-offer it in the future, but we're letting a few more in now. Now that you've actually seen it work. Wait till you see what we do on an advanced level.
Oh man, it feels so good. I was so happy when I was literally crying when because I had my kids ready. Like I have a 25 years old and a 17 years old, and they were like, "Dad, are you sure you're gonna do this?" I said, "Yes, I'm gonna keep doing this." and so, and so, then, but I had them ready in case something failed, and I had them ready because of some other circumstance. So I gotta have my dog with me at all times, and so I told them, you have to take care of my dog and stuff and this and that. But then when I got out and everything was settled, I was like so grateful about everything, and I'm just so grateful with you guys. I appreciate you. I love you guys, and I'm gonna keep learning, because I really think that we deserve to be free without a fear to approach this kind of business.
Well, you
Because
said
at
a
the
key
end of the
word.
day, yeah.
Is business. It's just business. You're going there to conduct a transaction. And the simpler you made it, the better it went, didn't it?
Oh, it was so simple. I didn't have to talk so much, and it was so rewarding. Like it's like, oh man, after all, it's so. I'm so happy.
Well, congratulations, Omar. I appreciate it. I'm going to get to another caller, but anything else you want to add?
No, that's it. I appreciate you. I love you guys. Thank you very much.
You're welcome. Thank you for participating and listening.